Order 32. Suit by or against trustee, executor, administrator. Rule 1 to 16. Every suit by minor shall be instituted in the name of the minor. Order 32, Rule 1 of CPC. A minor means a person who has not attained the age of majority within the meaning of Indian Majority Act. Whether a minor or attaining majority may, if a sole plaintiff applied that a suit instituted in his name by next friend be dismissed on the ground that it was unreasonable and improper. Yes. An agreement on compromise is entered into on behalf of a minor without the leave of the court. Such agreement on compromise under Order 32 Rule 7 of CPC is void against all the other party other than the minor. An agreement entered into or compromise on the behalf of minor without the leave of the court under Order 32 Rule 7 of the CPC, the voidable against all the parties other than the minor. Under Order 32 Rule 9 of the Code of Civil Procedure, a next friend or a minor can be removed for any of the above reason. If he ceased to reside in India during the pendency of the suit, where has interest become adverse to the minor, where he does not do his duty. Order 32 Rule 10 of CPC. On the death of the next friend, the suit shall be stay. On the retirement, removal, death of the next friend, under Order 32 Rule 10 of CPC, the suit is liable to stay. Proceeding in a suit relating to minor shall not be stay on attaining the majority by the minor. A suit through next friend can be filed by minor or lunatic. A person can act as a next friend if he is fulfilling all the above conditions: major, sound mind, not have any interest adverse to the minor or lunatic residing in India, who is guardian ad litem, a person appointed by the court to take legal action on the behalf of minor. Guardian ad litem uses under CPC means a person defending a suit on behalf of minor. A person can be appointed as a guardian under Order 32 Rule 4 of the CPC by the consent on his consent in writing. Order 33 Suit by indigent person. Rule 1 to 18. A person is an indigent person within the meaning of Order 33 Rule 1 if he not possess sufficient means to pay the fee of the plaint payable on the plaint. Sufficient means to pay the fee payable on the plaint, under which provision of the code an ingredient can be filed a suit. Order 33 Rule 1. In the connection with the suit or by an indigent person, a suit is deemed to be instituted on the day on when the application for the leave to the sue a proper is made. Where the indigent person succeed, the court fee shall be recovered by the state. In the case of application for permission to sue a proper is rejected, the suit is deemed to have been instituted under Order 33 Rule 15 of the CPC on the date on which application for the permission of sue proper was presented. Under which section Order of Civil Procedure a provision is made provided free legal service to the indigent person. Order 33 Rule 18. Where the provision is relating to the case of indigent person is given under CPC. Order 33. rejection of the application for the permission of sue for the proper bar a fresh application on the same cause of action. Suit of indigent person has provided under Order 33 of CPC. In connection with the suit by indigent person, the suit is deemed to be instituted on the day when the application for the leave of sue for the proper is made. Under which one of the following order of the CPC provision regarding the suit by indigent person has been given? Order 33. What does proper suit means? A suit by indigent person. Order 35. Interpleader. Rule 126. An interpleader should In an interpleader suit, plaintiff may claim cost or charge. In an interpleader suit, the plaintiff claim no interest in the state in the subject matter of the suit except the charge or cost. Interpleader suit is a suit instituted by a person who has no interest in the subject matter. Interpleader suit cannot be instituted where the suit is pending, in which right of all parties can be properly decided. Awarding the future interest. Discretion. Provision relating to interpleader suit are contained in Order 35. For the interpleader suit, which one of the following condition is not necessary? There must be a suit pending within the right of the rival claimant for the debt of the property in dispute, and by the property adjudicated is not necessary. Which is necessary? There must be said debt or the property in dispute, two or more persons claiming debt or the property is dispute adverse to the one another. A deposit a box of jewel with B as his agent. C alleges that the jewel were wrongly obtained from him, and the claim for B. Here B is cannot institute interpleader suit against A and B. Rule relating to interpleader suit has been provided in CPC under which one of the following order? Order 35. In an interpleader suit, there are several claimants claiming the property adverse to each other. Provision relating to interpleader suit can be contained in Section 88 of CPC, Order 35 of CPC. Special cases. Order 36, Rule 126. The provision regarding the friendly suit are Section 90, Order 36 of Code of Civil Procedure. Order 37, Summary Procedure, Rule 127. In which one of the following correct statement contain the summary procedure of the civil suit may be invoked for the recovery of a liquidated demand of money payable to the defendant arising out of the written contract? A suit under the Order 37 can be of the CPC can be filed on the basis of Hyundai's bill of exchange and promissory note. In a summary suit presented under Order 37 of the CPC, the code it is not necessary for the defendant to appear before the court within how many days of the service of the summons of the appearance. Order 10. There is no provision for trying a cases of negotiable instrument under CPC. True. The provision regarding the summary suit are Order 37 of the CPC. Provision in respect of the summary procedure is laid down in Order 37 of the CPC. Order 38. Arrest and attachment before the judgment. Rule 1 to 3. An attachment made before the judgment in the suit is dismissed for the default shall not become revived merely by the reason of the fact that order dismissed of the suit for the default has been set aside. attachment before judgment in the suit of dismissed in default is does not revive automatically on the restoration of the suit, under which provision of the CPC attachment before judgment is provided. Order 38 Rule 5 to 8. In the CPC, a court can direct attachment before the judgment in respect of the property in the proceeding pending before it, accordance with the provision contained in Order 38. Order 39. Temporary injunction and interlocutory order. Rule 1 to 10. Interlocutory orders are the issue by civil court during the pendency of civil proceeding. Injunction is granted under which provision of the CPC? Order 39, Rule 1. Defendant can claim the temporary injunction in a suit filed by the plaintiff to prevent the suit property being alienated and damaged. Temporary injunction may also be granted to restrain the dispossessed from the property, under which one of the following provision of the CPC 1908 the consequences of disobedience of the breach has been described. Order 39 Rule 2A. Under Order 39 Rule 2A of CPC deal with temporary injunction. In the case of the breach of the term which injunction is granted under CPC, court may pass an order of attachment of property and detention in civil prison. In the case of breach of any term on the temporary injunction was granted, the court may order the person in the breach to be detained in the civil prison an indefinite period, but not after the breach has ceased. Attachment of the property on the person in the breach, and if the breach continues from more than 1 year, sale the attached property, award the entire shall proceed to injured party as a compensation. Attachment of property shall remain operative under Order 39 Rule 2A of CPC for 1 year. Period of the detention of civil imprisonment as a consequence of disobedience or a breach of injunction shall not exceed 3 months. Which one of the following provision of CPC deal with the consequence of disobedience of injunction granted by the court? Order 39 Rule 2A. Where an injunction is passed without giving notice to the opposite party, the court will try to decide the application within 30 days. Rule 6 to 10, Order 39 of CPC deal with interlocutory order. Issue related to the jurisdiction can be tried as a plenary issue only when it can be decided without recording any evidence. The principle was laid down in the full bench in the MP court in the Nathu Prasad versus Singhai Kapoor Chand, which rule in the Order 39 of the Code provide that an injunction directed to the corporation is binding not only the corporation but also all the members of the officer and corporation whose personal action seeks to be restrained. Rule 5. An order for the appointment of court and commissioner is sought for recording statement of witness in the proceeding. File an interim injunction under Order 39 Rule 1 to 2. You will reject the application as not maintainable. Whether any order of the temporary prohibition and injunction granted under Order 39 Rule 1 of CPC will automatically revive with the restitution of the civil suit was dismissed for default? No. The provision relating to temporary injunction was provided under Order 39. If the party commit a breach of an order of the temporary injunction, its property may be attached. In which one of the following provision related to the injunction is mentioned? Section 95, read with order 39. In which one of the following order there is a provision of temporary injunction? Order 39. Under CPC, defendant can ask for the temporary injunction under the plaintiff if there appear to be in danger that plaintiff would waste the alienated the suit property. The plaintiff threatened to dispose of the property with the view of defrauding his creditor. Plaintiff threatened to the defendant to dispossess him from the suit and the property, all of them. Temporary injunction can be granted to a party establishing a prima facie case in his favor, balance of convenience in his favor, irreparable injury to him in the event of non-granting of injunction. Civil Procedure Code provided temporary injunction. A court shall not be granted temporary injunction where the plaintiff can be compensated by the money. Which one of the following statement is incorrect? Temporary injunction may be granted only at the time of institution of the suit. What is incorrect about temporary injunction? It finally settles a mutual right, the party, and direct the party for all the time to do and abstain from doing the thing. Under which provision of the CPC temporary injunction may be granted? Order 39, Rule 1. Appointment of receiver, Order 40. Under which order of the CPC the provision relating to appointment of a receiver has been provided? Order 40, Rule 1. The court may order to appoint a receiver of any property where it appear to the court to be just and convenient. Appointment of receiver of any property can be made when it appear the court to be just and convenient, whether before and after the decree. Under which provision of the Code of Civil Procedure collector may be appointed as a receiver? Order 40, Rule 5. Under which one of the following provision of CPC collector may be appointed as a receiver? Order 40, Rule 5. Which one of the following order appointed receiver is mentioned? Order 40. An order of appointment order for the appointment of court receiver. None of this. A person who is appointed to protect the disputed property is known as receiver. Receiver can sue and can be sued for the act of his official capacity by the third party with the leave of the court for appointing them. Order 41. Appeal from the original decree. Rule 1 to 37. In how much time respondent may be filed cross objection from the date of the service of the notice of hearing the appeal? In 1 month. In appellate court remain a case order for the remand does not cover the whole of the subject matter of suit. Appellate shall be entitled to get proportionate fund. Order 42. Appeal from appellate decree. Rule 1 to 3. Order 42 of CPC deal with appeal from appellate decree. Order 44. Appeal by the indigent person. Proper appeal has been provided under Order 44 of the CPC. Order 46. Reference. If the court is satisfied that case is pending before involve the question as to the validity of fact, the court should refer the matter to the High Court. Order 47. Review Rule 1 to 9. Section 114 of CPC should be read with Order 47 Rule 1. Under the CPC, when an application for the review is dismissed, no appeal lie. Under CPC, when the application for the review is dismissed, no appeal lie. An order for court rejecting an application in the review under CPC is not appealable. Miscellaneous. Res sub judice Section 10, res judicata Section 11, decree, judgment and decree Section 33, summon to witness Section 80. Temporary injunction Order 39, suit by indigent person Order 33, power of the appellate court 1/2, right to file caveat 148A. Equality of judgment debtor Section 49, legal representative Section 50, proper suit Order 33. Order 37, adjournment Order 21, suit by or against corporation Order 29, suit by or against corporation Order 21, execution Order 33, suit by indigent person. Section 10, res sub judice Section 11, res judicata Section 39, transfer of decree Section 151, inherent power of the court. Execution of decree Section 77, letter of request Section 82, institution of suit Section 28. Affidavit Order 19, arrest before judgment Order 38, commission to examine the witnesses Order 21A, sued by indigent person Order 33. Jurisdiction of the court to be decided by subject matter of dispute, pecuniary value of the court, place where the dispute arises. The CPC was amended by the CPC under Amendment Act 2002 to make provision strengthened. This section of the CPC procedure can be amended by the Parliament. Order and rule of the first schedule of the CPC cannot override the provision in the section. The expression each party shall bear his own cost implied that both parties are to be deprived of the cost. Set off. A person is allowed to file a suit of appeal without court fee. Means profit. Gain from the profit have the person having wrongful possession. Indigent. Set off. Adjustment of the defendant claim with the plaintiff claim. Means profit. Gain from the property by a person having wrongful possession. Indigent. Person allowed to file suit of appeal without court fee. Substantial allowances. Amount paid by the decree holder for the detention of the judgment debtor in the civil prison. Right to file caveat 148A. Institution afresh, setting aside ex parte decree for rehearing the case. Next friend, representation of a minor or a plaintiff of unsound mind of the civil suit. Legal representative, person representing the estate of a deceased. Garnishing, debtor of the representative of the judgment debtor is liable for the payment of the delivery. CPC contained 51 order. From which date CPC became operative? 1st January 1909. The plaint should be filed in duplicate. This rule was inserted by CPC 1999 amendment. Which one of the following suit has not a suit of civil nature? Suit involving the principal question of caste, suit involving the purely religious ceremony, suit for the recovery of voluntary payment of offering. Mere production of the photostat copy of a decree of a foreign court is sufficient. It is required to be certified the representative character central government in America. It was held by the Supreme Court in the court of Narasimha Rao versus Venkata Lakshmi. Issue must be confined to factum provendum. In a suit for the recovery of possession of the government, who will sign the plaint? Person nominated by the government. By which judgment the Honorable Apex Court upheld the constitutional validity of amendment made by the Code of Civil Procedure 1909 and 2002. Salem Advocate Bar Association of Tamil Nadu versus Union of India. Interpleader should. Section 88. Letter of request. Section 77. Precept. Section 46. Power to order discovery. Section 30. Where the High Court call for the record of any case, it is revisional jurisdiction. It operates as a stay such case before the subordinated court. A plaintiff cannot allow to court to sue afterward for any relief omitted by him in a suit. An executing court can either modify nor vary in the term of the decree. Under CPC, which one of the following statements are true as regard? Conclusively determine the party with regard to all or any matter controversy in the suit. Decree can be partially preliminary, partially final. It would be include any adjudication from which an appeal lies from an order. A decree became final when it is conclusively determined the right of the party. No appeal has to be preferred against the decree. Whether the pendency of the suit in the foreign court will preclude the court in India from trying a suit found in the same cause of action? No. Whether a minor on attaining the majority, if sole plaintiff apply in a suit instituted in the name of the next friend dismissed on the ground it was unreasonable and improper? Yes. Where the decree is for the partition of undivided estate addressed to the payment of the revenue of the government, the partition of the revenue of the government and the partition of estate in accordance with the law for the time being in force shall be made by the collector. In a suit for the institution A and B, despite of the summons of the suit has been duly served upon B, he did not appear on the day fixed on the summons on 1/3/1993, and the court consequently 1/3/1993 passes the ex parte decree against the B, listed the case on 3/4/1993 at the ex parte. The evidence of A can participate in the further proceeding of the court can be seek to set aside the ex parte decree if he is able to show the good cause for the non-appearance. Preliminary decree can be passed in the suit of partition, partnership, possession of the means profit. In which one of the following cases did the Supreme Court uphold the constitutional validity of the amendment of 1999 and 2002? Salem Advocate Bar Association versus Union of India. A court can return a plain presentation to the court in which suit is instituted, has been instituted at any stage of the suit. One of the one of the following of the CPC, a warrant of arrest against the judgment debtor may be cancelled by the court. Serious illness. Adjudication of the court of law may be decree and order. In which case Supreme Court held that the partition of the suit more than one preliminary decree can be passed. Fulchand versus Gopal Lal, AIR 1967. Rajasthan SRTC versus Krishna Kant, AIR 1995. Supreme Court laid down principle applicable to industrial dispute. An adjournment shall not be granted on the ground the pleader of the party to engage another court. A and B sue C for 1,000 rupees cannot set off a debt due to him from A alone. Issue arises when the proposition of law of the fact is affirmed by one party and denied by one party. Material. The CPC 1999 were enacted and recommendation of Malimat Committee. In which one of the following landmark judgments Supreme Court deal with the applicability of res judicata with the writ petition? Drayo versus State of UP. A court cannot return the plaintiff when the court has got no territorial jurisdiction, no pecuniary jurisdiction, no subject matter jurisdiction. The code of the CPC came into the force on 1st July 2002. The section of CPC can be amended by Parliament. Morgan Stanley Mutual Fund versus Karthik Das case is related to interim injunction, in which it is the statement of the claim of document by the presentation of which one is instituted. It is called plaint. Remedies available against the ex parte decree include appeal, review, application for setting aside the decree. In the execution of decree other than the decree for maintenance passed by A, whether shall be attached portion if the salary is 7,000 per month, 2,000. In which one of the following cases C can set off a claim? A sue C on the bill of exchange for rupees 500 and C hold a judgment against A for the recovery of 1,000. Multifuribleness means misjoinder of the cause of action as well as the parties. Attachment order may come into end by satisfaction of decree, setting aside the reversal decree, dismissal of execution of application of the decree holder, death of the decree holder, or agreement and compromise between the party. Which one of the following is deemed to be decree? Rejection of plaint, determination of a question under section 144 of CPC, adjudication under order 21 rule 58. Which one of the following provision of CPC precluded the plaintiff for institution of a suit? Order 9 rule 9, order 11 rule 21 2, order 22 rule 9. Who among the following is not a public officer within the meaning of 2 clause 17? Sarpanch and of the Gram Panchayat. Pleading under CPC essentially means plaint or written statement. where the decrees for the partition of undivided estate of the SSC, the payment of the revenue of government, and the partition of estate according with the law for the time in force shall be made by the collector. In the case of public nuisance, suit for the declaration of injunction may be instituted by two persons with the leave of the court. Where the appellate has withdrawn any appeal preferred against the decree passed ex parte in the application under Order 9 Rule 13 is maintainable. The court shall receive the application of the suit of indigent person where the other person has entered into the agreement with the application to the finances of litigation. The attachment before the judgment is dismissed in the default and non-prosecution revived automatically by the restoration of false. CPC is not applicable to which of the following, namely land law and local law. Fifth schedule. The authority to annual alter and or add the first schedule of the CPC rests with the High Court and the previous approval of the rules of the state government.